I think we left off at liquidated damages. We actually got through the point of damages, and if I remember what we said, essentially that damages are something that are available just by the nature of contract law. So even without having one word in the state solicitation about damages, if you can prove that a damage resulted because a vendor didn't do what they were supposed to do, you can theoretically collect on that damage. And I say theoretically because there's always a shortfall between, perhaps a shortfall, between what you have the right to do and what you can actually get. If a vendor's gone bankrupt, you can't get anything. If they haven't gone bankrupt, but you take efforts and they just don't pay and don't pay, sometimes it's difficult to get money. So, and the key thing about damages is the aspect that you have to prove the amount of damages. So you have to go through whatever complexity is involved to try to calculate specifically the value of what a vendor didn't do, how much it's worth to you, the fact that they didn't do something. And sometimes it's easy to prove that value, sometimes it isn't. So one of the shorthand things that are done to try to get away from this issue of you can only collect what you can prove is to have liquidated damages. Liquidated damages are supposed to be an approximation of actual damages. And I say approximation because it's, you usually use this when it's difficult to ascertain actual damages. But what you have to do for liquidated damages is make a good faith effort to try to identify the value of any particular instance of non-performance by a vendor. And what that means is, because we said before you cannot have penalties, you just can't pick a number out of the air. And I remember many years ago here when I was doing procurements, and I can remember at the Walter P. Carter Center was doing a security contract. I thought you were from Spring Grove.
Right, I'm just there.
Oh, because Carter Center is closed, yes, all right. And I was working with the maintenance supervisor who was in charge of the security contract and everything, and he was complaining because it was a requirement for the vendor to have submitted the police checks and various things for all the employees of the vendor for the security contract, and they were supposed to be on file so that if any time there was an inspection by JACO or whoever was going to do an inspection, that the personnel records would be there, that they could verify the things that were supposed to be checked were checked. And he kept saying that he had great problems with getting these personnel records to verify there were police checks and everything. And so he said, I need something that's going to get their attention. And because at that time I was very naive, didn't know that you were not to have penalties, I said, okay, let's make it $100 for every time, for every day or something like that, that they don't have the personnel record in the file. And he thought that was a wonderful idea, so we just put $100 in there. And I come to find out several years later that I wasn't allowed to do that. And the reason why, for liquidated damages, you have to go back and try to figure out what is the harm by not having something when it's supposed to be done. So what is the value of not having a piece of paper in a file on the day that you say it's supposed to be there? And if the issue is that unless and until there's an audit, there's no problem at all, then there's no value. There's no damages by the vendor not having it. Conversely, if there's the potential that the contractor hired people that were felons that should have been detected by a police check and wasn't, and there's thefts and things of that nature, then there could be a very substantial harm. Or if the fact that there isn't a piece of paper in the file means that once a week the maintenance supervisor is going to make a phone call or send an email or write a letter to say to the vendor, you need to give it to me, there's a cost for the time of that person taking that action. So what I'm trying to convey is you have to try to anticipate the totality of the cost for something not happening, and then that's the value of your liquidated damages. So now that I've said it without the slides, let's try to say it with the slides and see it makes more sense. The key to properly constructing liquidated damages is a serious analysis of the harm to the state from contractor non-performance. That's what I was just trying to say. There needs to be an actual methodology, not just pull it out of the air. $100 sounds good, and $100 will really get the attention of the vendor, because the vendor won't like to lose $100 for each person. They don't have that police record in the file. For each day they don't have it in the file, then I'll really get their attention, so $100 is good. And I guess if $100 wouldn't have done it, in my naivety, I would have said, all right, let's try $200, because not knowing that in essence it was a penalty and it wouldn't have been enforceable, that's the way I went back at that point in time, 20-some years ago. And I don't know whether the vendor got the information in the files because of that, or whether or what happened, but I never had a situation where the maintenance supervisor ever came to me and said that we still have problems. So maybe it did get their attention. But the issue is, if you construct liquidated damages, and if the vendor ever challenges those liquidated damages and says they are actually a penalty, then it can get to the point that if you invoke the liquidated damages, the vendor can file a claim. If the claim is denied by you, which presumably if you invoke the liquidated damages, you're going to deny the claim, and it's appealed to the Board of Contract Appeals, and the Board of Contract Appeals determines it is a penalty and not liquidated damages, it will not be enforced. So it will be as if you put nothing in your document to begin with. And it'll actually get back to the situation there. If the liquidated damages are ever deemed to be invalid, then you're back to the situation that you can collect actual damages if you can prove actual damages. All right, so let's see. And an agency must be able to explain. This is important, and I've had this many times with agencies where they have, and the typical situation is that the legislative auditors will audit an agency, and one of their favorite targets is contracts. And so they'll audit the contracts, and they'll see whether the vendor's performing as it's supposed to be performing, etc. And if they determine that the vendor is not doing everything it's supposed to do, they'll write up the agency. And almost invariably, one of the things they say is, you should have penalties in your contracts, which makes me cringe, because then the agency will send something into us, and we'll say this is a penalty, not liquidated damages, and they'll say, but the auditors made us do it. And we said, no, the auditors are not making you put penalties in there, and even if they use the word penalties, they just don't know that they're not supposed to use the word penalties. They're supposed to be talking about liquidated damages. And then we go through this whole thing back and forth about, okay, what are your liquidated damages? And they'll come up with a number, and the first thing I'll say is, how did you get to that number? And if right off the bat they just say, oh, I don't know, it sounded like a good number, right off the bat, that's the wrong answer. And so I'll say, okay, no, you can't go there. You have to come up with a methodology. You have to be able to explain it. Well, I don't know how to get there, and I'll give them suggestions. And if it gets to the point that through the suggestions the light bulb goes off and they can start thinking along the lines of damages, then okay, you can have these as liquidated damages. If it gets to the point that what they say is, I have no idea, I don't know that we have any damages, then the answer is, then you don't put liquidated damages in a solicitation. If you can't figure it out, there's no sense in doing it. And I'll probably have some examples here. Let's see. The calculation has to make sense. Hopefully everything in your solicitation will make sense. The liquidated damage amount must be reasonable in light of the anticipated or actual harm caused by the breach, the difficulty of proving the loss, the difficulty of finding another adequate remedy other than the liquidated damages. Must be structured to function as damages, not as a penalty. They can't pick a number. The amount or calculation means must be clearly identified in the solicitation contract. This can't be, I have seen agencies that have had a standard clause for liquidated damages and had a box that simply checked whether the liquidated damages will or will not apply. And they do nothing else than to check a box that said either yes, there will be liquidated damages, or no, there will not be liquidated damages. And the first answer is, it doesn't matter whether they check the box. If they had nothing more than to just say, yes, there'll be liquidated damages, they don't have liquidated damages. You must state either the specific amount of the liquidated damage for each breach of the contract, or you must explain a methodology for how the damages will be calculated. And hopefully I will explain that a little more in these slides. So just checking a box saying, yep, they're going to be there, means they're not there. And of course, with that particular agency, we said you can't continue to go there. You can't just have a check-off box for liquidated damages. And the same agency has a check-off box for retainage and doesn't explain anything more about retainage, which we've had difficulty with. And we get to retainage a little later. Aside from stating what actions or inactions will trigger liquidated damages, it should also be stated if there is a cap. Like, what we constantly have to remember, and this issue of risk that I have said over and over and over, we like to protect ourselves from risk. Vendors like to protect themselves from risk. And so the more that we insulate ourselves from risk, the more we are subjecting vendors to risk. And so we have to come up with this balancing act of what is a proper insulation for us and insulation for them, that both of us will have essentially a win-win situation. Because if we put liquidated damages so high that no vendor is going to either compete for the contract, or they'll compete, but they will charge such a high price that we are essentially paying, even if there are the circumstances of damages don't come into effect, then we haven't won. And so sometimes the best thing to do is to have liquidated damages, but have a cap of the maximum exposure that a vendor will be subject to for the liquidated damages. And I'll hopefully explain that a little more. Let's see, such as, after a stated number of occasions of damages, no additional damages will be assessed. We will assess liquidated damages for each day that something doesn't happen, up to a maximum of 5 days. And then you have to say, okay, does that mean that there's no more damages after 5 days? And it doesn't necessarily mean that. It just means that you're calculating that if you do any more than that, vendors are going to either walk away and not bid or bid too high. So you're sharing some of the risk with vendors by putting a cap. If there's a limit on the damages that can be assessed within a given time frame, i.e. only one damage occasion will be assessed within a 24-hour period, even if multiple occasions occur. If there's an incident, let's say if there's patient abuse at a facility, we might say that there is a liquidated damage of $500 for an incident of patient abuse, and the reason why you might say that is because you calculate for each incident of even alleged patient abuse, there has to be an investigation. You're going to take the average time of the investigation, the number of people involved in the investigation, the pay of the people, the actual pay of the people doing the investigation, the fringe benefits of the people doing the investigation, the report that has to go to somebody else to read the report of the investigation, and all that cumulatively is the value of an incident of alleged abuse, which could be $500, could be $1,000 when you get through with all the people that have to do something because of an incident. And so the issue is, do you say if there's 5 incidents or allegements of abuse in a day, will the vendor be charged $1,000 for each one of them, or no more than 1 in a day regardless of how many occur? And it's not that you don't think there's any value to the additional ones, it's just you think it's going to be better off for the state to give some insulation to the vendor from each and every instance. These are things you have to figure out in the planning stage. An easy example of liquidated damages is if there is a specific known loss because of it. And one of the things that I have heard, and this is a very clear example, is if you have federal money and the federal money says that a certain something, a certain qualitative level, a certain time frame, a certain something has to happen, and if it doesn't happen, the feds are going to subtract X amount of money from you because it didn't happen. That's a very specific, very clear liquidated damage. However much the federal government subtracts in its grant or whatever it's doing for you, I guess it's a grant, that's the amount of money that will be the liquidated damage, because the vendor's non-performance is what caused you to not meet that federal standard, which then caused the federal government to reduce the amount of money given to you. That's an easy way to calculate damage. Whatever it is, that's what the damage is. So you tell that in your solicitation to the vendors. And you may know what that damage is, or you may not know. But what you have said is how it will be calculated. The actual amount of damages, reduction by the federal government, that's what the liquidated damage will be. And so the vendor knows all it has to be proven is here's how much the feds reduced, which is going to be in a letter or something like that. That's the amount of damages. So that's an easy example. And what we have up there is if it's reduced by $50,000, the liquidated damage in that instance is $50,000. Let's see, if a certain qualitative level isn't met okay, here's another example of how you calculate. And sometimes these can get very, what you might call esoteric, so that you have to really think of what the consequence is. And it illustrates again that if you can think of it and put a value to it, you can put it in liquidated damages. So here we have a situation of complaints, that if the vendor isn't delivering a qualitative level that is preferred, let's say that they're supposed to do survey of customer satisfaction and they have to have at least a 90% level of customer satisfaction, and then we might say that for every 1% below the 90% level, there will be liquidated damages of X amount. And here's how you calculate the X amount. So that let's say that each complaint costs $100 to investigate and get back to the vendor. That a complaint comes in, somebody has to listen to the complaint, somebody has to check it out, somebody has to then somehow put in writing back to the vendor what the finding was, and let's say on average that's calculated that cost $100. So every complaint is $100 through that methodology. And let's say for every 1% decrease in customer satisfaction, historically the evidence is you get 50 more complaints a month. Well, since you've already calculated a complaint on average costs $100 to investigate, if you get 50 more complaints, 50 times 100 is $5,000 in increased cost to you because the vendor did not make that 90% satisfaction level. So the liquidated damage is $5,000. So you can see how it's calculated. Now you will have to be the one to determine whether you can get any of this information. If you have no statistics that tells you anything about the increase in customer complaints, you may not have liquidated damages. If you say there's no way I can calculate the value of a complaint, I would hope that you would be able to do that, but if you say you can't, then there's no damages. Because you can't calculate it, you can't say it. Do you know there's a reason why we have that in the bottom left-hand corner? Another example, and it shows you how subtle some of these can be. If inconvenience to the public can be quantified, and I'm sure one way or the other it can be quantified, it can be a basis for liquidated damages. Excuse me. Example, how to calculate liquidated damages for a highway project if a specific completion date isn't met. And this just shows you an example of how you might go ahead and do this. We talked about the Northridge earthquake and the incentive for the vendor to come up with and repair the bridges faster than usual, and the $12 or $14 million in incentive. Well, that was based in some way on doing this type of calculation. And this is done in construction type activities. So this is not a far-fetched example. So if you know that 1,000 cars an hour use a particular road, so you have a road that needs to be repaired, needs to have something done, and you know that you have 1,000 cars an hour on this road, and if not having the project done produces, just in this calculation, an additional 2 minutes per car delay. So 2 minutes times 1,000 cars is 2,000 minutes per hour, excuse me, of delay to the public. And 24 hours times 2,000 means that 48,000 minutes per day is the cost to the public of not having this completion date met. And if somehow they do a calculation that $12 is a good rate for the value of people's time on the road, et cetera, including businesses and people going to appointments, et cetera, and you say $12 per hour is the value of delay, or 20 cents per minute, you can take the 20 cents per minute times the 48,000 minutes and say $9,600 is your liquidated damage for each day the completion is not done. But you can see you have to have information, that you have to have the ability to calculate how many cars, you have to have the ability to calculate a value of people's time, and then it becomes just math. One times another is the value. And if you can explain it and it makes sense, you can have it as liquidated damages. Now that doesn't mean that even if a vendor doesn't complain about it at the time they submit a bid or proposal and seemingly have agreed to these as liquidated damages, that if it ever comes to the point that you try to invoke it and collect it, they still might say, wait a minute, that's not liquidated damages, that's penalty, and they might contest it. But at least if you have a good rationale that makes sense, if it gets to that point, you should still prevail. And hopefully if you have a good rationale and explain it, they will know better than to try to say it's a penalty. And Gary's going to say something.
No, I was just going to ask you a question. Suppose you had a nursing contract.
I have to keep talking, huh?
And the nursing contract is essential to the operation of the facility, and you've got multiple contracts, multiple different vendors, and you call a vendor and they say they're going to have 3 nurses for you on the second shift, and they will be there, and 2 of them don't show up. Now in your contract, you could have, would you call it liquidated damages, where they would be responsible for the overtime pay that we would have to try to keep people on to do that work?
That would be liquidated damages, yes.
Okay, so there's a real example where and I don't remember ever incorporating that into...
Well, because what you have to go back and look at is, if you're the nursing contractor, what is the certainty? And nursing is a shortage area. That's the first issue. That's why we don't have nurses to begin with, because it's hard to get them. And we turn to the private sector because we have difficulty finding nurses ourselves. But that doesn't mean the private sector has an unlimited capacity to provide nurses themselves. So the issue we have to ask ourselves is, yes, you can do liquidated damages, but if you do that and essentially tell a vendor, for every inability that you have to satisfy a demand, we're going to charge you something you didn't do that we had to substitute, are the vendors going to simply walk away from the bid at all, because they'd be willing to make their best shot at providing a nurse, but they're not going to do it if they have to end up paying for the fact they can't do it? So is that likely to happen, or is it likely that they're just going to jack up the prices, so we're paying as if every other shift they can't find someone? And that's just what you have to try to figure out. And you're going to have to talk to vendors, you're going to have to, for instance, you might put that in your specifications. And at the pre-bid conference, if you have all your vendors complaining bitterly, unless you change that, I can't bid. Well, if you believe them, if you have all of them saying it and it sounds plausible, you might do an amendment to take it out. If you have it in there and no one says anything about it, then you pretty much have validation that that is something that's reasonable, because they figure they can make the commitment and they won't have to pay the damages. And sometimes that's what you do. You put it in there and see if the vendors squawk. And if they do, you listen to how many, how sincere it seems to be, how logical it seems to be, and you decide whether you keep going down the path that you started on or whether you do a revision. But that is an example, and it's something you have to decide. You say you haven't done it, and you're thinking of it because of the fact that apparently you're not getting enough provision of nurses?
Well, other people here can speak better truth than I can, but we either don't get enough nurses, or we get commitments a week ahead of time, 48 hours ahead of time, and then you get a phone call a half hour ahead of time that the person's not going to.
Yeah, I would say there's more reason to have damages when you've had an actual response back that said, yes, we can fulfill the need.
And that's what I was referring to.
Yeah, it's one thing if they tell you, nope, can't find someone, but if they say, yes, we will have someone there, that's more likelihood because they've already told you they could do it. So, but these are examples. All right. If there are no statistics or data that reasonably substantiates the approximate loss due to vendor non-performance, liquidated damages won't be upheld if it goes to the Board of Contract Appeal or anything like that. All right, so that's a simple thing on liquidated damages. Any questions on liquidated damages? Most contracts don't have liquidated damages, but that doesn't mean that most of them shouldn't. You need to think, what is the damage? Can you calculate it? If you can calculate it, you can put it in there. But it must be specific, and everything must be very specific. If the instance of, if it's per occasion, is it literally every occasion? Is it a maximum per day? Is it maximum per week or a month that you will cap it? And you just detail, and you have to say, sometimes you can get into disputes over how specific you are. If something says, let's say the 90% satisfaction level and every 1% below that liquidated damages, what if they are 0.7% below? Does that mean that there will be 0.7 of the liquidated damages for 1%? Does that mean there will be no liquidated damages? You should address that, whether it's a full percentage or be prorated for every 0.1% or just what the situation is. Because these are things that can get you into situations of conflict with your vendor when you go to apply liquidated damages because it is maybe 0.9% below, when the vendor says, wait a minute, 0.9 is not a percent. You shouldn't charge me anything. Is the vendor right or is the vendor not right? You should address those things. Okay, insurance and bonding. The following slides provide a very brief overview. And I say brief because what we've done is basically pull out almost all the bonding and insurance information from this class. We're going to put it in a one-day class because it took about a half day to deal with that, and we were trying to shorten the class, which is going to be 6 days anyway, so it would have been 6.5 or 7 if we'd have dealt with this in its full complexity. Is insurance needed? And what you'd have to do is ask yourself some questions. Excuse me. What is the likelihood of risk to the state from a vendor's performance under state contract? So this is another thing you're looking at, risk to the state because of what a vendor is doing or not doing. Liquidated damage is one way to deal with risk. Insurance and bonds are another way to deal with risk. There is far more risk, and this is a statement, there is far more risk of loss to the state if a vendor is working on state premises or providing professional type services caring for wards of the state than if a vendor is producing a report. So if they have employees on site, there's more likelihood of harm to the state than if they have employees on their own site. If something happens on their own site, we don't have an issue generally. If it happens on our premises, we may be sued by somebody because it happened on our premises. If someone is providing medical care there is a greater risk of harm or loss providing medical care because of the possibility of malpractice than there is if someone just gives you an analysis of something. So you have to look at what you're getting and what the potential is of risk to the state. And my attorney said that I should put in this example of the $72.9 million Milliman case with the Maryland State Retirement and Personnel System? Retirement and Pension System, okay. Except I kept meaning to ask her, what is the example I'm supposed to tell you? But just remember, there's this $72.9 million Milliman case with the state retirement system that I think retirement got a judgment against the vendor for $72 million for something the vendor didn't do. And I think the vendor was giving the retirement agency actuarial advice, which means they were doing calculations of how much do they have to charge us for pension benefits, how much does the state have to pay into it for a given level of benefit when someone retires. And supposedly Milliman, it came to light years later that they had done a very poor job of projecting, and so I think there was a huge shortfall between what supposedly was going to be paid in that would be sufficient for payouts and what actually happened. So supposedly they got a judgment against the vendor because they did not do due diligence in calculating these benefits. And I will have to find out before the next class if that's number one right, and number two whether they actually got the money, because I can't imagine a vendor's going to pay $73 million and actually we'd collect the money, because that would be far, far beyond the value that this vendor was paid for those calculations. And that's the issue of why vendors don't like to have quote-unquote unlimited liability. They want caps. They don't want to be paid $1 million to do something and be hit with a judgment of $73 million because of what they didn't or didn't do. That they would walk away from a contract if they thought there was too much risk.
That's what I thought insurance or bonding is for, to protect against that.
Well, and that depends.
Also, let me just point out that in the Millman case, that
You're familiar with it?
No, but the way he describes it, the reason why there was a collection ability in the state, I'm sure, is because we required a certain amount of insurance, maybe $100 million, in a specific category, which is called errors and omissions. Right? So if we had not specified that in the RFP, they may not have had that ability to have their insurance company or them pay us $72 million. So the point I'm trying to make is that in the insurance clause that we have in most RFPs, we sort of copy it from one to the other. You know, you have a certain liability insurance, you have a certain requirement for workman's comp and so forth. But we do have to look at the individual nuances of the type of vendor that we're hiring. Comment.
Okay. I don't think I've ever seen a state contract with $100 million of insurance.
I think it's $1 million.
Usually $1 million, $5 million, something like that.
There has to be some way of collecting that.
Well, I don't know if they did. See, that's what I said. I have to do some more checking, and I had meant to do that before I actually presented this, because I'm not familiar with the case specifically. So it doesn't make a whole lot of sense for me to bring up something that I can't tell you what it is. But it's there. I don't know. Maybe you can do an internet search or something and try to find out, or whatever. But the issue, you're right. That's the whole thing about what bonding and insurance is supposed to do. That if there is a loss, what is the likelihood that you can collect that loss from that vendor? And if you are not sure you can collect it, you can require insurance or bonding, and what that means is somebody else is coming in, a third party, that brings additional assets to play that will have the ability, without fail, will have the ability to pay the amount of insurance or the amount of the bond. Now, the thing that always is perhaps the difficult aspect is collecting on the bond or the insurance. The certainty that the action or inaction is going to trigger the collection from the bond or the insurance, because vendors, insurance companies and bonding companies don't like to pay money out. And so unless there is a clear-cut situation where a vendor has defaulted or a vendor has caused some kind of harm, lots of times the insurance company or the bonding company will also fight the state and say, wait a minute, we don't agree that this was an actual situation of default, and because we don't agree it was a default situation, we're not going to pay the value of the performance bond because it wasn't default. Just because you, the state, aren't satisfied with the level of performance doesn't mean it is default. And so, no, we're not going to pay you. And in those kind of situations, unless we're going to take the bonding company to court, we may have to live with the fact that no, we can't get the money. So just because you have something in a solicitation, it's better than usually not having it, but it doesn't mean absolute certainty that you're ever going to be able to collect on it. And we have to keep that in mind. Let's see. The risk involved to state property, state employees, clients of the state, visitors, public, other contractors, staff, etc. has to be assessed. The objective of insurance excuse me, is for the risk of loss to be borne by the contractor and its insurer, because we're talking about insurance now, not by the state. In the event of loss, the issue becomes, and this is a technical terminology, you can tell this is very technical terminology, and you may not understand this. What it comes down to is who has the deep pockets, and what that means is who has more money. Because if someone is hurt, what they're going to do, what their lawyer is going to tell them to do, is sue everybody involved. And even if you can't get collected from the party that might be the most responsible, you're always going to go against everybody, because maybe you can collect it from somebody that is not as responsible, but at least can pay the judgment. So the issue of deep pockets comes into play. And the state has deep pockets. Deep pockets. Who has the financial ability to pay an injured party for an injury or other loss? I just said that sues all potentially liable parties to ensure it collects from someone. Often the state has more financial resources than vendors. If there's a judgment for the injured party, the state could be forced to pay some or all of the judgment if the party that is primarily responsible, meaning the contractor, doesn't have insurance or the right insurance or enough insurance, etc. If they have a $5 million policy and the judgment is for $20 million, someone's going to pay the extra $15 million. And if the vendor declares bankruptcy, that somebody could be the state. And it was a different situation when we had absolute sovereign immunity, which means going back to, I guess, the Middle Ages and the sovereign kings of England, when you could never go against the king, and because the king was immune from anything and everything, the king, the queen, whoever it might be. And that concept has followed through and been transferred to governments, that governments for many years were immune from being sued. They can only be sued if they passed laws that allowed themselves to be sued. And over the years, most states, most governments have, to varying degrees, given up the right of sovereign immunity. They allow themselves to be sued. And Maryland has given up most of its sovereign immunity, so we can be sued. And there can be judgments. And we have the ability to pay for it. Okay, so that is about as much as I'm going to say about insurance in this class, since there will be a class on insurance. You go to what is called contract security. And these are the permissible, in terms of Title 21, forms of contract security. Bonds, a bank certified check, cashier's check, treasurer's check, trust account, cash. So a vendor can give you $1 million, and you can thank them for giving you $1 million in cash. And you can hold that, or you can go to Brazil or whatever. Pledge of securities, that's a joke, yes. A pledge of securities backed by the full faith and credit of the U.S. government or bonds issued by the state, an irrevocable letter of credit, in some circumstances the grant of a mortgage or deed of trust on real property. So these are what are permitted in Title 21 to be forms of contract security. And of these, the ones I have had are bonds and an irrevocable letter of credit. I cannot remember an instance I've ever had a vendor give me anything else.
No escrow accounts?
Escrow account? Well, an escrow account is probably going to be one of these, like a trust account. Yeah, it means that there's money somewhere.
Right.
That's the security for this.
Yeah.
Yeah. All right, details regarding bid and contract security are in 210607 and also in the Board of Public Works Advisories, 1996-3 revised and 20064. Generally, specific forms and specific clauses should be included in the solicitation whenever such security is required. And one thing I can say and should say, even though these are the available as per 0607, the interpretation of the attorneys, and this is not a formal interpretation, but it's I don't know whether I say off the cuff or informal interpretation, is that we can specifically limit in the solicitation which of these forms of security we will accept. We can say, here's the following forms of security that are acceptable: bonds, irrevocable letter of credit, and let's say a bank certified check, period. Like, for instance, we do not want to get in this situation of handling a mortgage, because then you get into what's the value of a mortgage. Is it overvalued so that we can't get the actual amount? Cash has a value. Face value of a bond or something like has a value. These other things may be questionable what the value is. So you can have those, and these are situations where you want something in addition to insurance and in addition to simply being able to sue a vendor for actual damages or liquidated damages to try to get reimbursed if there are damages to the state or to other parties such as citizens, employees, etc.
I'd just like to say one thing. Realize that there's a cost to a bond, and it's normally 1% that the vendor is going to pay. So, going to add bonding as a requirement, especially without bonding.
Yeah. I don't know how much I'm going to say on this now, so I'll see what I'm going to say, and then if I haven't said it in here, I'll say it. Well, let me just say it now. Aside from the cost, and anything that cost a vendor is going to be added to their cost to your contract. So that's the one thing. You're paying for it if you require it. So that's the thing. You figure you're going to pay for that. So is it worth the fact you know you're going to pay for it? The second issue is almost inevitably you're reducing competition because of it. There will be vendors that won't be able to get a bond, that won't be able to get insurance. And the question you have to ask yourself is it worth the limitation on competition? Because usually the vendors that cannot get bonds or insurance are the small vendors, the minority vendors, etc. So you basically are keeping them out of the game, which means you're preventing them from the possibility of winning a contract, performing a contract, using state contracts, etc., to get bigger, to go after bigger contracts, to grow, to employ more people, etc. So everything has the pros and the cons. That it's an additional level of security for the state, but it's an impediment to vendors. It's an added cost, and it's an impediment to vendors. And so you have to think of these things. And we go through this in a fair amount of detail in what will be the bonding and insurance class. And things like, well, in the bonding insurance class. A bond is similar to insurance, but unlike true insurance that is intended to protect against a loss of some kind, a bond is intended to help assure an action of some kind will happen or pay what might be regarded as an equivalent value if the desired action doesn't happen. And hopefully I will explain that a little more. Bonds can be specified in one of two ways: either a specific value, $100,000, $500,000, $1 million, or a percentage of the value of the contract, 5% of your bid price. So we don't know what your bid price is going to be. We don't know if you're going to charge $100,000 or $1 million, but 5% is 5%. Whatever it is, you have to put up 5% of that as a bond. The common types of bonds are bid bonds, performance bonds, payment bonds, and fidelity bonds, which are otherwise called honesty bonds and defalcation bonds. Purpose of a bid bond. It seeks to guarantee that if a bidder or offerer is notified that it has been awarded a state contract or recommended for an award, that will sign the contract. So that's what a bid bond is supposed to do. Get to the point that when you're tapped on the shoulder and said, gee, congratulations, you went after this contract, you won it, and here, now sign the contract, that the vendor will do that. Because when they sign a contract, that's when a performance bond kicks in. But until they sign the contract, a performance bond doesn't kick in, so the bid bond's supposed to bridge that gap and not allow a vendor to basically walk away from its bid. And you might ask yourself, why would a vendor go to the effort of submitting a bid, submitting a proposal to win something, wins it, and then doesn't follow through? And the answer could be that after they submit it, they realize that they basically missed the mark in terms of pricing. That when they see what other people bid, they say to themselves, what did I miss? They go back and they look at their price and they say, oh, now I see what I missed. And they really don't want to perform because they're going to lose money. So they would rather walk away than lose money. The bid bond's supposed to make sure that doesn't happen. So that's what that's there for. Performance bond, and again, we say a lot more in the performance, in the insurance and bonding class on this. This is just a high-level view of what they are. Performance bond, to provide monetary payment to the state if a contractor does not perform a contract as required. In other words, to make the state whole for the value of required performance that was not achieved. And if we have a performance bond, the easiest and the cleanest way in which you're going to collect on a performance bond is if a vendor goes bankrupt. If the vendor goes bankrupt and they basically don't exist anymore, there is no question you can collect on a performance bond. If the vendor doesn't go bankrupt and you are claiming they are not performing, then unless it is absolutely clear-cut they are not performing, you may have trouble collecting the amount of the performance bond, because the vendor is going to try, the surety is going to try to avoid paying the money in most instances. And what we need to realize that even if we say, let's say there's $1 million performance bond, that doesn't mean even if the vendor goes bankrupt, we get $1 million. Because the vendor has a couple other options. The surety has a couple other options. They can step in and help the vendor to perform. In other words, they can go out and pay for additional resources to help the vendor perform if they are clearly not performing, in lieu of paying us money. If it's $1 million bond and they figure that for $100,000 they can get the vendor over the hurdle to perform, they'll go out and pay $100,000 rather than pay us $1 million bond. Or they can come in and offer to bring in another contractor to substitute for that contractor in lieu of paying the bond with our approval. And we cannot unreasonably agree to these things or else they will refuse to pay the bond. So they have some leverage. We have to go after them to get the money. So unless it's clear cut, we may have a problem collecting the money. And this is one of the reasons why in the procure class, we have said that when you have problems with, and we will say this in the perform class, we will say it to a fair degree in the perform class, that if you have problems with a vendor and there is a bond, you must keep the surety informed of the problems. Because if you don't, and you then at one point in time say, okay, vendor, you're in default, surety, you pay me the amount of money. If we have deprived the vendor, the surety, of the opportunity for these two aspects, they're not going to pay the money. Because that supposedly is part and parcel to this agreement of the two-way agreement between us and the surety, that we have to keep them informed so they can interject themselves at a point that they may not have to pay the amount of the bond. And if we don't, we may, number one, have the vendor going bankrupt, and number two, not have the ability to collect on the bond because the surety says, you didn't let us know. So since you didn't let us know, we're not paying the money. So we have to keep them informed at appropriate times. A payment bond. And taking this from Title 21, actually State Finance and Procurement 17101B. Payment security means security to guarantee payment for labor and materials, including leased equipment under a contract for construction. So if you go to this Finance and Procurement article, this only applies to construction contracts in the State Finance and Procurement article. The same section, the objective is the protection of those who furnish labor and materials in construction. Going to be purpose to protect subcontractors and material men on state and or other public projects where they have no lien on work to be done. Excuse me, again from 17101. And what this means, basically, is this has evolved over time. Some of you may understand the terminology mechanics lien, that if you have somebody doing work on your house, work on your car, work on various things, and they use a subcontractor, and let's say you pay the contractor for work that was done, but the contractor doesn't pay their subcontractor, the subcontractor can sue you for the money. And it doesn't matter that you have paid the prime contractor, because if the subcontractor hasn't been paid, they have the right to go against both the prime contractor and the person who employed the prime contractor, the right of a mechanic's lien. And so payment security is supposed to have something to guarantee that that won't happen. That in the event the prime contractor does not pay, that instead of them having the ability to go against the state in this situation, they will go against a payment bond to get paid for their labor and materials, etc. So in construction, it's required to be there. And here we say that although this is not in the Finance and Procurement article, but we have also had situations where we have required payment bonds for the purpose of paying the employees of a contractor if the contractor goes bankrupt, and possibly subcontractors. And this came about because there was a situation with, I think, with the Department of Juvenile Services, where they had a vendor who was providing a group home, and the vendor got into financial straits and for something like a month didn't pay their employees. And the employees were a little displeased with not getting paid for a month. And so the employees complained to the state, and they said two things. Number one, I don't get paid, I don't go to work. If they don't go to work, now we have these kids that are there, what happens to the kids? State has to take them out, put them somewhere else on an emergency basis, etc. Plus, the state has been paying this contractor. So, even though the state's been paying them, the employees haven't gotten any money, and it got into a very sticky situation. So at one point, the governor at that time, Governor Glenn Denning, suggested that we have some protection in state contracts to try to prevent that in the future. And sometimes we have, not usually, because usually it's a more difficult issue, but at least it's a possibility. So it's required for construction. You can have it in other types of contracts, but you just need to know you have these types of bonds that you can have in there. Yes?
What about the language that we just added to RFPs and contracts,
Prompt pay?
prompt pay? Does that,
That just says they'll pay their contract. Yeah, that says they will pay their subcontractors. But still, if they claim they don't have the money, that's only if they have the money. If they go bankrupt or something like that, there's still nothing to go against unless you have a bond. And the final bond is fidelity, defalcation, honesty, to help protect against theft of state funds or property by contractor employees. When are they appropriate? When contractor employees have access to a significant amount of state property or funds with little or no supervision by state employees, i.e., you're the housekeeping contractor, you're here from 5 o'clock at night to 9 o'clock at night, and from 5 to 9 there might be 2 or 3 people in the building, but they are certainly not everywhere, and who knows what mischief that people can get into by going through desk drawers and various things and picking up equipment. So you can have a fidelity bond that says that if things disappear, and then you go back to the issue of can you prove that the people of the contractor stole them, but you can have a bond, and to the degree you have it, to the degree you can prove loss, then you can collect against this bond. So that's what that means. Occasionally I've had it. And here's one that we say that there should not be. And I have seen this from one particular agency, and other agencies, now that I think about it, have tried to pick up on this, and we have advised, well, not we have not advised, the Office of the Attorney General has advised that this is not something that should happen. And at one point, and it was the lottery, state lottery, for a while required vendors to post a protest bond, which said that supposedly if a vendor filed a frivolous protest, the lottery would go and collect the value of the protest bond because of the frivolous protest. Of course, the issue is, what is a frivolous protest? Now, believe me, I can tell you lots of frivolous protests. But whether a vendor does it in a particular instance is going to be questionable. Whether you can prove it was frivolous is another thing. So just generally, the recommendation is do not even have such a thing as a protest bond, which most of you never even thought of it, never would have thought of it. So this thing you never thought of, you shouldn't do. Remember that. And it was good that you didn't think of it, because you shouldn't do it. I would say, are there any questions on bonds or insurance? And I guess I will say, are there any questions? Although, if you really want to know a lot more about it, you have to take the class that hasn't been written yet. So isn't that nice? You can take something that I don't have to offer you yet. Any questions? Anything that you're just dying to know about insurance and bonds? Good. I don't have to talk about it. All right. Let's see. Contingencies. Writing specifications. As previously and hereafter stated, as issues such as bonding and insurance, minimum qualifications, limitations on liability, liquidated damages are discussed and decisions are made in planning as to what to include in the specifications. Contingencies should be discussed and agreed to in terms of fallback position if there is significant vendor resistance to certain provisions. This shortens reaction time during the procurement stage. For instance, the example that Gary brought up, should we put in liquidated damages? Liquidated damages for nursing contracts. And okay, let's put it in there. But in the whole discussion of whether it's appropriate to put those liquidated damages, then you will discuss, all right, how far are we going to go down this road? If we have one vendor, if we have no vendor squawk, obviously we'll keep what we have. If we have one vendor squawk, but we have 5, 6 other vendors that don't say anything, okay, we'll still think it's a pretty good deal. If we have 2 or 3 vendors squawk, are we going to still keep the liquidated damages, or what's our fallback? Will we, number one, offer a reduction in the amount of liquidated damages rather than a complete abandonment of it, simply reduce the amount? Do we just take it off the table immediately? What will we do if complaints come up during the procure stage? And if you've discussed that in planning and you've basically made your decisions, what's going to trigger what actions, then if those things happen, you don't have to get together again and try to figure out what to do, because you've already predetermined what to do at what time under what circumstance. So that's the issue of contingencies. So just because you do something in planning doesn't mean that you won't have the fallback of what happens if you get pushback from vendors when you actually put it on the street. And the more you plan, the more you have those contingencies, the less you have to try to figure out when the contract is on the street, the solicitation is on the street, of what to do in those circumstances. Okay, no exercise. Required vendor information. It needs to be emphasized that all required information, vendor information such as references, financial statements must be in the name of the bidder, offer, not a parent organization. It is not unusual that if you have a vendor that is a subsidiary of another vendor, that when they respond, they will do two things. They'll, number one, say that the vendor responding is this subsidiary. But when they give the financial statements, when they give the insurance or the bond or something like that, it's in the name of the parent. And when you get into legalities, the legality is that only the entity, the legal entity that is submitting the bid that theoretically would sign the contract is the only one legally liable for anything. So just because you have the financial statement of the parent or insurance of the parent doesn't mean you can go against the parent if the entity that's bidding is a subsidiary. And so because of that circumstance, you want to make sure that even if they have done that, if they have blurred, here's the entity bidding, but here's the backing we're going to give you, you go back and say, all right, since you've given me the financial statement of the parent, I want in writing that the parent is going to guarantee the performance of the subsidiary. And what you'll typically get is, no, that's why we have the subsidiary. So we're insulated from liability. Well, then don't give me the information about the parent, give me the information about the subsidiary. If that's the only one I can go against, that's the only one I want information about. And what you might get is not much information, because vendors create shell corporations that have no assets, that have very little ability to pay liabilities, etc., so that they don't have to carry it on their own balance sheet. And to the extent that you have a hollow corporation that is the one that's your bidder, you don't have much guarantee. So that's where you either say they're not responsible, or you say, before we're going to even think of contracting with you, we need some guarantees. Either you're going to give us more insurance, more bonds, or a guarantee from the parent corporation, or else we simply will say, since they have no pockets, not just not deep pockets, but no pockets, we're not going to take the risk of awarding to you. So this is something you need to make sure who is responding. This is the clause we have on this subject. If an offerer that seeks to perform or provide the services required by this RFP is a subsidiary of another entity, all information submitted by the offerer, such as but not limited to references and financial reports, shall pertain exclusively to the offerer, unless the parent organization will guarantee the performance of the subsidiary. If applicable, the offerer's proposal shall contain an explicit statement that the organization will guarantee the performance of the subsidiary. So that's what we say. And if, despite saying that, vendors don't do it, we go back to them and say, either you're going to guarantee if you're the parent, or give us the financial information, the insurance, etc., of the offerer, bidder only. Minimum vendor requirements. This is one of my, and I'll have to use, I will say two words, favorite subjects, but I don't mean favorite in a positive sense. This is one of the issues I typically have the most issues with. Minimum vendor requirements that are called various things. They could be called minimum vendor qualifications, minimum quals is a shorthand. These are conditions that must be met by vendors for their bid or proposal to be considered for an award. Excuse me. If you have a specification, well, I'll keep reading this. Although usually not identified as such, minimum requirements, minimum qualifications are aspects of whether a bid or offer will be deemed to be responsible. We are using this as a shorthand for making a determination of whether a vendor has capability to perform our contracts, and probably capability, reliability, and integrity. And we don't say that. But what it gets down to is, if you drill down, that is what we're saying. We're setting these as threshold for minimum evidence that a vendor is capable, reliable, and has integrity, which is what that fourth bullet says. The concepts of responsiveness and responsibility were discussed earlier in this class. We didn't do it in this class, did we? Anyway, we discussed that in the Procure class. We discussed it to a degree in the Overview class, and are covered in Procure. Yeah?
This might be a good time for you to just mention why you have such enjoyment with this.
Aversion?
Because of what we the procuring people, confuse in the RFP.
I think I have about 10 or 15 slides.
Well, I think if you just mentioned it at the beginning, and
well, it's the same thing as anything. It's an impediment to vendors. It's saying in advance, here's what you have to look like to even have the chance of bidding or submitting an offer. And if you don't look like this, don't bother. And the problem is that what we typically do is over-require, over-specify what those minimums are supposed to look like. We want to be ultra-safe. We want to make sure somebody looks exactly like what we want this contract to come in at. If it's a $5 million contract, we want them to have done not just one $5 million contract, but 2 or 3 $5 million contracts. Or we may say we want them to have done a $10 million contract, because we want to really make sure that they are capable of doing a $5 million contract, and if they've done a $10 million contract, then that's pretty good insurance that they can do a $5 million contract. So we're putting up these impediments, and what we're doing is couple-fold. Depending on how much research or how well you have looked at the marketplace, we may be establishing our threshold so high that only 1 or 2 vendors can meet it. And if only 1 or 2 vendors can meet our threshold, you're going to pay for it through prices. The other thing you're doing is, I use the analogy of when you graduated from either high school, college, whatever it is. You're there and you're eager and you're capable and you're ready to work, and you go and apply for jobs, and the first question on the application is generally, what is your experience? And the answer is, well, I don't have any, because I just graduated from school. I want to work for you and give you all my talent and energy and learn and give you the benefit of me, so that then I will have experience by working for you. Well, I'm sorry, but I don't want to hire anybody that doesn't have experience. Well, if that's the case, if no one would ever hire anybody without experience, no one would ever be hired, because no one can get experience until they're hired. And there's a protection about wanting someone with experience, but there's a danger. And that danger is you'll never get anybody new, anybody that could be the greatest thing since sliced bread. You never know when you're going to have the next Bill Gates or the next guy that invented Facebook or something like that that is the one who's applying for your job. And so you are running that risk of what is more important, the fact that you are assuring yourself supposedly that someone has done this work before so they can do it for you, or that you are precluding somebody from even proving to you that they can do it and showing that they can take it beyond what it's ever been before. Plus the fact that we usually don't specify these things very well. And I'm going to go through some examples here of what I mean don't specify very well. And I'm going to differentiate the two primary competitive procurement methods, sealed bidding and sealed proposal. And I'm going to say there is more reason to have minimum qualifications for a sealed bid procurement than there is for a sealed proposal procurement. And the reason is very simply, in sealed bid, you don't do evaluations. It's basically take it or leave it. Are they responsive? Are they responsible? And you can do some degree of determination about responsibility, but generally it's not a lot of determination. And you also want to typically award these more quickly, so you don't want to take time to do determinations. So because you want to make sure that the bids are comparable, which means that they are from companies that are able to do the work, there's more reason to set minimum qualifications as far as responding, so that you can make sure that they are theoretically responsible and the bids are comparable. In sealed proposals, you don't have that situation. You're going to do an evaluation. And of course, the hybrid is multi-step, where you can, is a sealed bid, but a sealed bid with some degree of technical determination. So you might do the same thing with a multi-step, but with sealed proposals, since we've talked about the flexibility of sealed proposals, the fact that you can have vendors come back and give you additional information, the fact they can change their proposals, the fact you have oral presentations and they can describe things to you, and you can meet with them over the table, face to face with these oral presentations, and you can gauge their capability directly from talking to them and having them explain things, means that you have the ability to go beyond what they have merely done before. So that's why I differentiate between sealed bidding and sealed proposals. Let's see. When you're talking about sealed bidding, the issue of responsibility, the typical situation is that unless you know there is a negative, the default is you're going to find them responsible. And so this is a way of kind of putting up a threshold for what responsibility is by having a minimum qualification that if you meet this, theoretically you're responsible. If you don't meet this, theoretically you're not responsible. You don't say it that way, but that's what it comes down to. This has no bearing on whether a bidder's bid is responsive or his proposal is reasonably susceptible of being selected for award. These are qualifications, qualities of the bidder or the offerer, not its bid or the proposal. That's why it's not responsiveness, that's not why it's not reasonably susceptible of the proposal. It is the vendor itself. In sealed proposal procurements, meeting the minimum requirements may also be accepted, meaning the bidder is responsible, but frequently there will be other considerations such as financial solvency, etc., that will be factored into a determination of whether an offer is responsible. In sealed proposal procurement, it is far more likely that an offeror's proposal will be determined not to be reasonably susceptible of being selected for award than that the offer itself is not responsible. And what that means is we are conditioned to say a vendor is reasonably susceptible or not reasonably susceptible, and sometimes we miss the distinction that that terminology applies only to the proposal the vendor submitted, whether the proposal itself is reasonably susceptible or not susceptible. The vendor is separate from its proposal. You can have a vendor that gives you an immaculate proposal. They could have paid someone $50,000 to write a proposal that looks like the greatest thing that you've ever read. And the vendor may have absolutely no capability of implementing that proposal. So it isn't just what the proposal says, it's what is the capability of the vendor itself. And you can have a vendor that, you can have IBM that has capability, that has the deep pockets, that has all of that, and they don't give you a good proposal. So it isn't that IBM isn't responsible, it's just their proposal might not be reasonably susceptible. So they're two different things. And that's what the minimum qualifications focuses on: the vendor, not its bid, not its proposal. For either sealed bid or sealed proposal procurements, not meeting the minimum requirements will result in the elimination of a bid or offer from award consideration. This is a fatal situation. If you establish minimum qualifications, the first thing you're supposed to do is determine if a bidder or offer meets those minimum qualifications. If it does, you continue on. It doesn't mean they will absolutely win, absolutely be thereafter determined to be qualified. It just means that if they pass the first test, they get to go to the second test, but if they don't pass the first one, they're out. So if they don't meet minimum qualifications, they are eliminated. They must be eliminated. You do not have leeway to decide, well, they're only a little bit short of the minimum qualification, so I'm just going to waive the minimum qualification because they're close. A minimum qualification means minimum. And that's the whole thing about it, that you are drawing this line in the sand that says, I don't care whether you're close to the line, I don't care whether you touch the line, you have to go over the line. And if you don't, you're eliminated. And you have to keep that in mind, that that's what that means. And if you don't eliminate a vendor, if you do this waiver thing and someone else files a protest, number one, you should uphold it, and if you don't and it's appealed, it will be upheld by the Board of Contract Appeals because you have violated your own requirement in the solicitation, which you don't want to do. I say over and over again, mean what you say what you mean. If you say this is a minimum requirement, you should mean it's a minimum requirement. If you don't mean it, don't say it. In such an instance, the vendor will merely be notified it was eliminated for failing to meet the minimum requirement. So that's what you'll say. You didn't meet minimum requirements, you're eliminated. But what you don't say, but what it really means is you were found not responsible. What is the relevance of this to the planning class? Oh, it's just time that we can take prior to the break. Since there is no recourse to a vendor not meeting minimum requirements, they will be eliminated. Agencies should be very judicious in setting minimum requirements and solicitations. You should be very careful about setting this line because you now know the consequence of you setting this line. But the procurement method being used for procurement has a large impact on the advisability, as I've already said. In sealed proposal procurements, usually, and this is my story and I'm sticking to it, usually there is no need for minimum offer requirements in a sealed proposal procurement. Because in a sealed proposal procurement, what you're basically saying to a vendor is, convince me you are the best vendor to do what I want. Convince me. And they can try to convince you, they can tell you all the experience they have, they can tell you the people they're going to use, they're going to tell you the process, they're going to tell you all kinds of things to convince you they're the best, in combination of what they're going to do, how they're going to do it, and what they're going to charge for it. So you don't have to specify anything to judge whether someone has the necessary experience to do your job. You should be able to have that from their proposal and from their oral presentation. You should be able to judge whether a vendor is capable of doing something, without saying, nope, you have to have 3 references, and if you don't do 3 references, you're not qualified. And what we will get to after the break is you can have references that seem to be very clear and seem to indicate capability when they really don't. And what I mean is a vendor who has $1 million reference actually has more references than a vendor has 5 $10,000 references. So if you say you have to have 3 references to even be considered, A vendor with a single huge reference won't be able to meet your qualifications. One that has, or the other thing is you can have a vendor that has 3 references and you contact them and you ask the vendor whether they would hire them. I mean, whoever had the vendor work for them, whatever they're called, the employer, the customer, etc., would you hire them again? And they could be hemming and hawing. Well, if they came in and gave a really low price, yeah, I guess maybe would hire them again. And what they're saying to you is, they really didn't do a good job. I would really have to have a lot of things go right before I'd hire them again. But they're not saying, nope, I wouldn't hire them again. Conversely, you could call another reference who has 1 customer, and all they do, you can't get them off the phone because they're raving about how great this vendor was. They came into this difficult situation with almost no time. They brought in an army of people. They came in, they analyzed, they got things together, they did the job, they did it better than we ever could imagine. We would hire them for anything, everything. We would recommend them to you, to anybody who ever asked us. But if you required 3 references and they have 1, no matter how great that reference is, you can't consider them. And it's another instance where you're precluding yourself from even having the option to consider them and having those 2 circumstances come into play. So why don't you take a break and we'll come back and talk some more in 15 minutes.